My name is Nomfundo Jele from the Law Society of South Africa. I'm joined by Nkosana Mvundlela, who sits on various committees of the Law Society, and we'll be discussing the Divorce Backlog Project. The purpose of the project is to fast-track divorces to get finalized. This video will focus on a judgment from the Supreme Court of Appeal, in terms of which the SCA clarified the proper interpretations of Section 77 and 78 of the Divorce Act 70 of 1979. Legal practitioners did not apply to courts for variation orders on divorce matters granted previously to now specifically make provision for pension fund interest. However, to avoid any additional costs and delays, it is important that the prayers be correctly captured in the pleadings. Hello, Nkosana, and welcome.
Hi, Nomfundo, and welcome to yourself too. Hi to all your viewers, should there be any in the future.
Okay, Mr. Mvundlela, what happens if a divorce order relating to the division of a joint estate was granted simply on the basis that the joint estate would be divided equally between the parties?
Thanks, Nomfundo. This is a very important question because currently courts are sitting with backlogs of applications to vary court orders which were granted on the basis of the sentence you just mentioned alone. Therefore, the Supreme Court of Appeal in the case of Ndaba versus Ndaba has made the matter much more clearer that there is no longer an automatic alleged or intended forfeiture of the non-contributing spouse to the pension benefits of the contributing spouse. Therefore, by law, that pensionable interest is automatically to be shared on a 50-50 basis if the parties were married in community of property. Therefore, should it be that the order is granted, as you say, then it would be required of the parties to still approach court for purposes of complying not with the need to divide the pensionable interest, but with compliance with the specific requirements as would be required by certain pension administration companies insofar as the wedding is concerned. That is the only purpose that the parties would be approaching court for.
So is my understanding correct that there's no need for a party to approach the court again in a situation where a divorce settlement agreement or court order did not address pension interest?
Yes. It is not necessary to approach the court to vary the order in order to talk to specifically the pension interest. It is necessary for the parties to go in if the pension administrator, for instance, GPF or Old Mutual or whoever is the company that is holding those pensionable interests, requires the wording of the court order to direct them otherwise. But the substance of the pension interest itself is not what the party would be going to court to do in order to include it in the court order. It would be for purposes of aligning it with the requirements of the pension administration company that would be administering the pensions.
All right, thanks so much for your time.